Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. Right now, my law firm, Charles International Law, is involved in defending a client whose actions implicate some of the very same constitutional authorities that are at issue in the protests currently playing out in Minnesota. In Pennsylvania, our client is being prosecuted for repeatedly and vociferously contacting a local district attorney's office to protest what she believed was prosecutorial misconduct and a failure to pursue allegations of sexual assault. And I happen to agree with her. In Minnesota, we're seeing widespread public opposition to large-scale federal immigration enforcement operations and increasingly aggressive law enforcement responses to that opposition. Now, at first glance, these may appear to be very different situations, but constitutionally, they're not. They raise the same core question, one that is becoming critically important as Americans confront levels of authoritarian government overreach that we have not meaningfully seen in generations, at least since the Civil War era. Where is the line between protected protest and unlawful interference with government operations? To answer that, we have to go back to the beginning. We have to start where the framers started. The American Republic was born out of protest that was deliberately disruptive. The Boston Tea Party was not polite. It was not orderly. It was designed to apply pressure to government and authority. And when Madison and Hamilton wrote the Federalist Papers after the Revolution, they assumed and even hoped that that kind of dissent would continue. Madison famously warned that liberty feeds faction the way that air feeds fire. His solution was not suppression, it was to build institutional resilience. What the framers feared was not protest. What they feared was a government that intentionally insulated itself from protest. But, and this matters, even at the founding, the framers understood that there was a distinction between verbal and political disruption and physical obstruction. That distinction carries straight through to modern First Amendment law. So, in the simplest terms that I can come up with, here's the line. You are absolutely allowed to observe law enforcement. You are allowed to film law enforcement. You are allowed to yell at law enforcement. You are allowed to berate law enforcement. You are allowed to call government offices over and over again to complain. That is all protected by the First Amendment. What you're not allowed to do is physically interfere with lawful government action. You cannot link arms and stand between officers and a person they have a lawful right to arrest. You cannot block vehicles. You cannot use your body as a physical barrier. You cannot restrain the officers. And you definitely can't use force or threats of force. That's not a speech issue. That's a conduct issue. The constitutional line is not volume, it is not profanity, and it is not persistence. In general, the line is physicality, which brings us to our case here in Pennsylvania. Once you understand that distinction, Kimmy Baylor's case becomes pretty straightforward. Kimmy did not physically interfere with anything. She did not block an office, she did not threaten anyone, she did not touch anyone, and she didn't impede an arrest. She spoke repeatedly, angrily, directly to the government. That is exactly what the petition clause exists to protect. Pennsylvania law itself recognizes this by requiring that harassment serve no legitimate purpose. Petitioning the government about prosecutorial misconduct is not only legitimate, it is foundational to a functional democracy. Kimmy did nothing wrong. And these distinctions also apply in Minnesota. People are observing ICE operations. They are filming agents. They are following them into public spaces. They are shouting at them. They are warning their neighbors. They are protesting outside of federal buildings. All of that is verbal and expressive disruption, not physical interference. And that is protected by the Constitution. Where protests cross the line is when they are involved throwing objects, blocking officers, physically preventing arrests. That is where the First Amendment stops protecting protesters and starts to protect everyone else against physical conduct. Everyone should understand that. But again, simply being loud, angry, and present does not give law enforcement the right to declare interference and shut it down. Law enforcement does not have a constitutional entitlement to silence, compliance, or convenience. If we as a nation start to blur the distinction between verbal disruption and physical obstruction, then the First Amendment collapses. If yelling starts to be equated with interference, then protest starts to disappear. If persistence starts to be equated with harassment, petitioning disappears. If inconvenience becomes criminal, then accountability disappears. The framers did not write the First Amendment to protect calm disagreement. They wrote it to protect forceful, uncomfortable opposition short of violence. So to state the rule as clearly as I can, you may protest the government vociferously. You may berate it. You may observe it. You may disrupt it politically. And you should. But you may not physically interfere with lawful government action. And that's the line. Kimmy stayed on the right side of it. and I have every bit of confidence that she will eventually prevail. And the vast majority of the protesters in Minnesota are staying on the right side of that line as well. Contentions otherwise by the Trump administration do not hold water, and definitely won't be on the right side of history. And that line is not radical. It is the Constitution. Thanks. Stay safe, but not too safe.